Today, a new statement of changes has been released. Today is 24th of June 2025. This has just come to my email. I've read, briefly analyzed it. So I'm going to give a brief overview of what is changing and which areas it is changing. There is one change. So these are the different appendices, immigration rules that are changing. Appendix International Armed Forces, Appendix Long Residence, Appendix Continuous Residence, Appendix Private Life, EU settlement scheme. This is quite a major one. Yeah, I'll get to that in this order only. And part 9, changes to refusals of applications or cancellation of permission. So let me start with the first one, changes to Appendix International Armed Forces and international civilian employees. This is a very specific area. It doesn't apply to the general public. There is some contract between US and UK. Some 50 federal US Department employees are going to come. So they will be granted visa on entry. So they'll just come to the border rather than applying. There will be waste of time, whatever. There are policy reasons for that, and they would just be granted permission on entry. So it's a very specific thing that has been incorporated for the Ministry of Defense reasons. It doesn't apply to the general public, so I'm not going to go into much detail about it. The second one, which does apply to everyone, Appendix Long Residence. So the qualifying period requirements are being changed to clarify that as a British citizen is considered lawful presence except where British citizenship has subsequently been deprived. So I'll explain what that means. So there are some nationalities who have got the British passport and subsequently they realize that if they take this passport, I think Malaysia or some other countries are there, they don't recognize dual nationality or something. So in that case, people want to give away the British citizenship. So they have already gone through the part. For example, they stayed in the UK for 5 years, got ILR as a spouse or partner of someone for a British citizen. They got ILR. After that, they got British citizenship. And after that, for some reasons, they decide, it may be anything, tax purposes, any other reasons, they want to renounce their British citizenship and they want to take back, they want to keep their whichever citizenship they had. In that case, what happens, by default you don't fall back to ILR. So it doesn't mean that from a visa you go to ILR, then you go to British citizenship. So if you give away British citizenship, you don't fall back on ILR. It doesn't work like that. You won't have any permission. That's the default position. So it's a welcome change that they have done. So for example, the person has already spent 5 years and then ILR and all, whatever the periods they've spent, they will be still considered under the appendix long residence. They can apply under the 10-year long residence and get indefinite leave to remain. They will have to apply for ILR again. Remember that once they renounce, they have some short period of time where they have to apply for long residence ILR and then get that ILR. So that is allowed. So the period they have spent on that visa, for whatever visas they've spent, let's say skilled worker 5 years, then they got ILR, then they got citizenship, and they have been living here. So all that will be counted towards their long residence application. So they renounce the citizenship and then apply for long residence ILR. So they have included the qualifying period requirements are being changed to clarify that time spent as a British citizen. So they became British, let's say after 6 years being in the UK. For the next 4 or 5 years they stayed in the UK. After being about 11 years, let's say, in the UK, they decided to renounce. So the time period spent from the point they got British citizenship till they are renouncing it, all that period as a British citizen will be counted towards long residence as legally residing in the UK. That is what the change has been done. Changes to Appendix Continuous Residence. Rules are being changed to remove inconsistency. Okay, so there is some inconsistency. I'll explain that. For long residence application, same thing. Another thing which is in the long residence, which is a 10-year long residence commonly, if you apply being in the UK on a 10-year period on different visa categories, let's say student, skilled worker, graduate road, whatever you did, the combinations, and after 10 years you apply for long residence ILR, 10-year long residence, being legally in the UK for 10-year period. So if you apply for that, any time that is spent in the Channel Islands, so Isle of Man, Jersey and Guernsey, that is not counted towards it. So there is an inconsistency. For other ILR categories, usually I think it is counted, but there was an inconsistency. I remember advising on these matters where in Appendix Continuous Residence, if out of those 10 years, let's say you spend 1 year in Jersey, so that is not counted in the 10-year long residence period. So this is what they've done. What they are saying, we will in future treat time spent with permission in crown dependencies, that is Isle of Man, Jersey, Guernsey, on a route equivalent to those in the UK as a lawful presence in the UK. For example, in Isle of Man, yeah, we do visas for the islands also. So in Isle of Man, they have a worker migrant visa similar to the skilled worker visa in the UK. So if you spend, let's say, 2 years as a worker migrant over there, that can still be counted for your 10-year long residence in the UK. So summarily, that is what it means. Another example would be people move to the islands. I've seen many times for on spouse visas. We've done several applications on those areas also. For example, Jersey and Guernsey don't even have a financial requirement. If a British citizen moves over there, brings their spouse, people usually plan, they go there, they stay there for 5 years or some period, and after they qualify, they either apply for a UK spouse visa or they come after getting ILR to the UK or British citizenship back to the UK. So in that case, that is one example. Also, Isle of Man, the financial requirement over there for spouse visas, I'll just take a simple example. In the UK, it is increased to 29,000. However, in Isle of Man, even today, it is not increased from 18,600 to 29,000. It still remains 18,600. We've done many applications for the island also, for the Isle of Man. So Isle of Man has 18,600 financial requirement. Jersey and Guernsey don't have any financial requirement. They have maintenance and accommodation. So we do those applications also. So people sometimes migrate over there, they complete their periods, and at some point they come to the UK, either on a spouse visa back in the UK, or after getting ILR, or after getting British passport over there. So this is a common practice, people do that. So in that case, what the rules are changing is, any time that you spent over there, uh, that will be counted towards your long residence application inside the UK. So let's say the example, hypothetically, if I have to take, you come on a spouse visa over there, spend 2.5 years over there, then whatever you met the UK financial requirements, let's say you have a savings or whatever, and then you move to the UK, you decided to move to the UK, let's say the main applicant or both of you got a job in the UK, you decided to move and apply for a UK spouse visa. Island spouse visas are different, UK spouse visas are different. So currently what used to happen was, if you come back, you have to start your count again and all of that. In summary, let's say you spend 2.5 years on the island and then come back in any of these islands, three of them. Then you come to the UK and you will anyways have to spend 5 years on the spouse visa and complete and get ILR. So that will anyways be required. But for whatever reasons, things fall off, whatever happens, divorces happen, people, relationships break down. If you are going on the 10-year long residence and to living in the UK, that 2.5 years that you spend on the island will also be counted towards the 10 years. So that is another example similar to the skilled worker one. So that is Appendix continuous residence. They've added time spent over there can be counted towards UK 10-year long residence. Summary of that. Private life. So private life, there are several paragraphs. I'll just summarize this. So this, we had raised this through our Immigration Lawyers Practitioners Association on many occasions with Home Office. They had promised that these rules will come into play, and yes, finally they have added. So firstly, for this is the young adult visa. People call it young adult. Someone between 18 and 25 who spent half of their life in the UK, they get private life permission, and then they have a 5-year route to settlement. This was introduced subsequently, so there were different phases, changes happened, and there was a cohort of individuals who were before the changes happened, so they were favoring changes. They reduced the period to 5 years, and they can, on 5 years they will get settlement in 5 years summarily. So that was a good change. But for the previous cohort, which was under the old rules, they were not, there was a transitional gap, there was a break, I would put it that way. So they have filled up that gap, and anyone on that route can qualify under the 5-year route, whether you came under the old rules, new rules, whatever rules. Okay, so that is what is happening to Appendix Private Life for 18 to 25. Another one, where is it, changes? Yeah, and another one is another cohort of children who have lived in the UK, not born in the UK, very important. So children who are, I'll differentiate and explain it. Children who are born in the UK, lived in the UK for 7 years, they directly apply for ILR, parents apply for their dependents, etc. That is understood and everyone understands that. Now this is for children who have lived in the UK for 7 years. So changes are also being made to allow children who have lived in the UK for 7 years to qualify for settlement after 5 years. So they have spent, the reason is they wanted to bring, so such children who have spent 7 years, they also come in line with the 18 to 25, which is 5-year route to settlement. So summarily what they have done, anyone who has spent, who was not born in the UK, lived in the UK for 7 years, a child, then they can go on the 5-year route to settlement. That is the change that is happening. So they are bringing in line with that young adult one, which is for 18 to 25-year-olds, and similarly for the 7-year child who has spent 7 years but not born in the UK. So that is another one. I'm just summarizing it. There are long paragraphs. I'm just trying to summarize what changes. These are already, we were expecting this for a long time. They have been raised with Home Office, all these gaps, and they have made these changes. The biggest change is, yes, this is the biggest one, EU settlement scheme. We didn't expect this, so I'll explain what the change is. Once you come to the UK, so this is for anyone who has pre-settled status. Automatic upgrades to settled status has started since January 2025, I think beginning of the year. If they have tax records, benefit records, etc. Usually this happens only to EU nationals, not to family members. With family members, I've made another videos where I've explained, family members will usually, I don't expect ever, they will never be automatically moved on to the settled status. They will always have to apply. Remember this. I get these questions on the channel many times. Family members who have pre-settled status, husband, wife, children, parents, whatever that is, they have to always apply for settled status. This automatic extension only applies for someone who has EU passport. They started living in the UK before the end of the transition period, 31st December 2020, and on that basis they have pre-settled status. Okay, so what is changing over here? There was an absence requirement. So in the 5 years qualifying period of settled status, you are not allowed to be outside the UK for more than 180 days in any 1 year, any 12-month cycle, similar to skilled workers and other areas. So now, and there was a lot of confusion. Many times EU nationals traveled, they spent outside more time, etc., etc. It's quite a mess in that area. Yeah. So, and they were not aware of the rules. So the government wants to streamline this, and it's quite a very big streamline, I would say. And there are some exceptions for COVID and all, but still people have stayed outside the UK. So an ideal case would be an EU national who has pre-settled status, but he has spent outside the UK more than 180 days, and that way he would break the continuity of residence and he may not qualify for settled status. That's how it will be. But then the government has said what they are going to change. They are going to make it easier for them to simplify the assessment of continuous residence. These changes enable a pre-settled status holder, that individual, to be granted settled status where they have been a resident in the UK for at least 30 months in total in the 5 years, in the most recent 5 month 60-month period. So if I'm applying today as an EU national, I had pre-settled status, they will look back last 60 months, which is 5 years. Out of that, at least half of that 5 years I should have lived in the UK. 30 months 30 months out of 60 months I should have been in the UK. This can be any 30 months period within that 6-month period. So they may have absences for even a whole year that will be excluded. For example, they got pre-settled status, they may not have lived. Worst case, if you want to stretch it beyond, out of the 60 months, let's say the first 30 months, 2.5 years, they were not even in the UK. But the next 30 months, they came and they continued living in the UK. Yes, they will qualify. It's quite a very big change. So the 180 days absence requirement is gone for EU nationals or EU national family members who want to switch from pre-settled to settled status, upgrade their status. This is a very, very big change. We didn't expect that this will happen. I think the government, so almost summarily what is going to happen, anyone who has pre-settled status will definitely get settled status. This will be applicable to EU nationals, but this does not change the situation for family members. For example, family members, if let's say you are an unmarried partner and you separate, then there are no retained rights. Then this rule may not help you. You are a spouse of an EU national. I'm just taking some examples here, and you have not lived together for 3 years, so your marriage has not lasted for 3 years, uh, and of that 1 year you didn't live in the UK. So if all those things you have not met, then you don't meet the retained rights requirement. So family members, if they have broken the relationship before, it may not help them. But then yes, if they are together and all of this, definitely this will be a smooth ride even for family members and the main EU national. So summarily, 180 days requirement is gone for EU nationals to qualify for indefinite leave to remain settled status. They have to look at the whole 5 year period, and they can be out for 30 months. Any 30 months they can say, half of the whole 5 year period they can be out. On the basis of the next half, wherever you can put, you were in the outside the UK for 1 year, you came, stayed 1 year, then you were outside UK. If the total is reaches inside UK for 30 months in the last 5 years, you are done. You can apply and you will qualify for settled status. This is the biggest change that has happened. The last change is about refusals of applications or cancellation of permission, mandatory for people excluded from asylum protection. So this is basically someone who does not qualify. They have a mandatory refusal for whatever criminal convictions, etc. For them, they don't have the opportunity to apply under other immigration routes. That is the summary of it. That's the change that they are adding, because usually if that fails, people usually go on to the spouse visa route, parent visa, whatever. They are trying to stop them from applying under other immigration categories. Anyone who is, what do they state? Anyone who are excluded from asylum and humanitarian protection or non-refoulement. So they will not have the opportunity to make other applications under other immigration categories. That's what they are adding. So these are all the main changes. I think other things are just minor changes. So these are all the changes summarily in today's immigration, the statement that has come, statement of changes. Yeah, I'll just post this video, and yeah, maybe summarily as we get more information, I'll make detailed videos on these topics. And thank you very much for watching.